We got that first witness out of the way. We're pushing on now. So how it sort of works in the UK courts is the prosecution will present their case, and then at half time, the judge will decide whether he can, in sort of certain circumstances, submit a no case to answer, say, look, that case is so poor, the jury can't decide on it. The judge can just throw it out under certain circumstances. So the witnesses have come forward. We've cross-examined the police officers involved with the investigation, and we come to the half time. Now, we've presented no case to answer, and it's quite a clever sort of legal precedent, which was R.V. Milton. You need to look this guy up. He was a police officer in the Midlands in the UK, and he was driving at 155 miles an hour on the M54 near Telford, and the black box in his police car obviously logged it all, and the police decided to prosecute the policeman. And he argued that he was testing his driving ability and that he was an experienced driver and he was evaluating his skills. And what came from it was this statute, basically, that speed alone is not sufficient for dangerous driving. Police officers and ambulances will break the speed limit to respond to emergencies, and speed alone is not enough. Now, I was charged with dangerous driving. The reason why I was charged with dangerous driving is we have a 6-month statute of limitations in the UK. So they only found out about it about 8 months after it happened. So they were basically trying to negate that by saying, we'll do dangerous driving because we can negate the statute of limitations on speeding. However, it's a much higher threshold. So our argument at half time was speed alone's not enough. Even if what they say is true, to drive fast is not enough. The roads allegedly were good. There was no traffic. It was the middle of the night. So this was our argument. Now, the prosecution hadn't heard of this case or didn't think this case would be applicable. So we hand in this case to for no case to answer, sort of a submission. And the judge goes away to his chambers to look at it, and he's a bit of time. And he comes back and he sits down and he's like, when I first heard of this case, I was reminded of R.V. Milton. The prosecution are scrambling now thinking, what is this case? And they're looking at it because they're thinking there's no way this is getting thrown out at half time over some technicality. And he looks and he says, I have given it some thought. Speed alone is not sufficient for dangerous driving. However, to drive that length at those speeds, as the prosecution allege, would be considered dangerous from a fatigue or endurance point of view. And in my mind, I'm like, let me introduce you to some guys over in the States, right? This is just pop to the shops for them. And he says, in my view, there is a case to answer and we'll proceed with the defense.